Mr. Louis Ng.
Sir, I stand in support of this bill. The Employment Act is the cornerstone of our employment regime. It provides an additional layer of protection for employees beyond contract law. It recognizes that there are certain fundamental protections that employees and employers should not be allowed to contract out of. It also recognizes that there are underlying power imbalances that may weaken the nature of the consent in an employment relationship. It is thus important to regularly review the Employment Act to ensure that its provisions take into account the reality of the employee-employer relationship. With this in mind, I have a number of clarifications to make on the interpretation and application on the proposed amendments. Section 14(1) is intended to protect employees against unfair dismissals by allowing an employee to lodge a claim with the Employment Claims Tribunal, where he has been dismissed without just cause or excuse. However, there is no definition of what constitutes dismissal without just cause or excuse. Without clear definitions, the protection against unfair dismissal may be ineffective because instances of unfair dismissal are often not clear-cut and can be easily disguised. Civil society groups have documented examples of such stories. In one case, a mother was told to leave when she returned from her maternity leave, as the company had carried out a retrenchment exercise while she was away. However, she also reported being nitpicked and mentally abused by her superior while she was pregnant, and strongly suspected that the superior took the retrenchment exercise as a chance to get rid of her. In another case, a pregnant lady was dismissed shortly after returning from hospitalization leave for severe morning sickness. While poor performance was cited for the reason of the dismissal, the company did not seem to have a problem with her work performance prior to her pregnancy, even praising her for being an exemplary role model. The odd actions of her employers, such as locking her out of her work email account, which she could only access using a temporary password, and hiring a new person whose job scope and job title were similar to hers, only occurred after she returned from hospitalization. The hospitalization and one incidence of lateness to work, which were both caused by her pregnancy, seemed to have escalated into her dismissal. In a disability discrimination case, a stroke survivor with mobility issues was dismissed after a colleague had reported witnessing the individual slipping and falling on the way to the toilet. Can the Minister provide examples of unfair dismissals? Would the Minister further consider providing clear definitions of what constitutes dismissal without just cause or excuse under subsidiary legislation or as guidelines? Can such regulation or guidelines also include specific forms of discrimination on the basis of gender or disability? This would clarify for employees their rights on discriminatory dismissal and assist the Employment Claims Tribunal in adjudicating unfair dismissal claims. Next, Section 27(1) currently specifies a list of permissible deductions. No deduction beyond this limited list may be made from an employee's salary. However, this defined list seems to have been expanded by the new Section 27(1)(I), which authorizes any deduction made with the written consent of the employee. It appears all deductions are permissible with the employee's written consent unless it is specifically prohibited. Can the Minister clarify if the intended effect of Section 21(1)(I) is to permit any kind of deduction as long as there is written consent? For instance, Section 27(1)(C), which permits deductions for meals supplied by the employer at the request of the employee, will be removed. Would it be permissible for an employer to now deduct the cost of meals with the employee's written consent? If that is the case, what is the rationale behind removing Section 27(1)(C) if such a deduction would still be allowed under Section 27(1)(I) as long as the employee consent is obtained? It is worrying that 27(1)(I) is intended to be interpreted so broadly that all deductions, unless specifically prohibited, are permitted with the employee's consent. As I mentioned at the start, our labour laws provide additional protection on top of contractual consent. Permitting deductions as long as there's written consent by the employees seems to be a regression in the protection of our labour laws. It is undisputed that in reality, many employees can be pressured or coerced into giving false consent. Can the Minister confirm that the new Section 27(1)(I) remains limited by prohibited deductions under other statutes, such as Section 22A and 25(6) of the EFMA? Can the Minister also clarify whether Section 27(1)(I) is subject to any other limitations? Next, under the new Section 27(1)(F), an employer can make deductions from an employee's salary to recover any advance or loan. This is a potential loophole for improper deductions to be made. Can the Minister clarify whether employers will have to maintain and produce documentation of such loan or advance to prove the legitimacy of deductions under this section? Can the Minister also shed some light on how the written consent requirement will be implemented in practice? How will the Ministry keep track of whether written consent has been obtained, and how will the Ministry ensure that such written consent is not obtained coercively? I welcome the new section 27(1)(a) and 1(b), which clarifies that an employee cannot be penalized for withdrawing written consent to deductions. Section 27(1)(a) requires that the employee withdraw their consent any time before the deduction is made. Can the Minister confirm that an employee is only required to withdraw consent before a specific deduction transaction is made? In other words, it remains open to an employee to withdraw consent for a certain category of deduction throughout the course of employment. Further, what are the penalties and consequences for an employer who penalizes an employee for withdrawing written consent? Next, the new section 21(1)(a) of the Employment Claims Act 2016 allows the Employment Claims Tribunal to draw adverse inferences where a party fails to provide evidence in breach of their obligation under other written laws. Can I confirm that this would mean that adverse inferences may be drawn against employers if they fail to produce key employment terms and salary slips, which they are required to maintain under the Employment Act? Would the Minister consider taking this a step further in future reviews of the Employment Act and Employment Claims Act in reversing the burden of proof where the employer is required by statute to retain certain records? Lastly, I welcome the amendments to Section 89, which recognises employees' freedom to consult medical doctors or institutions of their choice without prejudicing their entitlement to medical leave. I would further urge the Minister to extend this principle to the work injury compensation regime in future reviews of WICA. I understand that the assessment and diagnosis of the first treating doctor, who is also often the doctor chosen by the employer, is often preferred over doctors the employees may subsequently consult in the assessment of permanent incapacity under WICA. It would be appropriate to harmonise the positions under the EA and WICA by recognising that the injured employee is both entitled to consult and to have their permanent incapacity assessed by a medical practitioner of their choice. So, notwithstanding my clarifications, I stand in support of the bill.